Before you answer that question, understand this. The moment you explain where that money came from, you have just handed law enforcement the legal justification to take every dollar of it. And in most states, they do not need to charge you with a crime to keep it forever. Civil asset forfeiture is one of the most aggressive and least understood legal mechanisms in American law enforcement, and the question, where do you get this cash, is not small talk. It is the opening move of a process that ends with your money in a government account and you in a courthouse trying to prove a negative. Most drivers answer it immediately. They explain. They justify. They hand over the documentation they think will help. And in doing so, they provide the very cooperation that converts a question with no legal teeth into a forfeiture proceeding with permanent consequences. Subscribe to this channel right now, because the video after this one covers what happens after they take the money, what the forfeiture hearing looks like, and what your attorney needs from this moment forward to get any of it back. Before the words, you need to understand what that question actually is, because where do you get this cash sounds like curiosity and functions like a trap. Cash in a vehicle is not contraband. Carrying cash is not a crime. There is no federal law, no state statute, and no constitutional provision that prohibits a person from transporting any amount of currency in their vehicle, on their person, or in their luggage. The United States Supreme Court has never held that the presence of cash alone constitutes probable cause for a search or a seizure. And yet, in jurisdictions across this country, the discovery of cash during a traffic stop, cash that was lawfully earned, lawfully withdrawn, and lawfully being transported, triggers a sequence that results in that cash being seized, held, and in many cases permanently transferred to the law enforcement agency that took it, without a single criminal charge being filed. The mechanism is civil asset forfeiture, the legal process by which law enforcement seizes property alleged to be connected to criminal activity and initiates civil proceedings against the property itself rather than against the person who owned it. Not against you, against the money. And in a civil forfeiture proceeding, the burden of proof is often reversed. You must prove the money was not connected to criminal activity, rather than the government proving that it was. The question, where do you get this cash, is the first step in building the record that makes that reversal possible. Every answer you give is evidence in a proceeding you do not yet know has begun. Here is the legal framework that governs cash seizures during traffic stops, and understanding it is what allows you to recognize what is actually happening at the moment that question is asked. The Fourth Amendment requires that a seizure of property be supported by probable cause, specific, articulable facts that would lead a reasonable officer to believe the property is evidence of a crime or was used in furtherance of a crime. Cash alone does not constitute probable cause under any controlling Supreme Court precedent. In Illinois versus Cabal, the court addressed the use of a drug dog during a traffic stop, but left intact the principle that a stop's investigative scope must be tied to the stop's original justification. In United States versus Place, the court addressed the seizure of luggage and established that a seizure of property requires the same constitutional foundation as a seizure of a person. The presence of a large amount of cash, standing alone, has been addressed in multiple federal circuit court decisions, and while outcomes vary by jurisdiction, the consistent thread is that cash alone, without additional articulable indicators of criminal activity, does not supply probable cause for seizure. What builds probable cause is what happens after the cash is found. The officer's questions, your responses, your nervous behavior, your inability to explain the cash's origin in a way that satisfies the officer's documented skepticism. The drug dog's alert, which, combined with the cash, creates the articulable fact pattern that many courts have found sufficient to support seizure. Your explanation of where you got the cash does not protect the cash. It provides the narrative framework within which the officer builds the case for taking it. Here is what the officer is actually doing when he asks, "Where do you get this cash?" Because the question is not an investigation of the cash's origin. It is a construction of the probable cause record. When cash is discovered during a traffic stop, the officer is in a legal position where the cash itself is not yet seizable. He needs more. He needs articulable facts that connect the cash to criminal activity. Facts that go beyond the cash's existence and amount. Your answer to, "Where do you get this cash?" is designed to produce one of two things. The first is an answer that the officer documents as inconsistent. Inconsistent with where you said you were going, inconsistent with your stated occupation, inconsistent with a timeline that does not account for a cash withdrawal of that size. Inconsistency becomes an articulable fact. The second is an answer that the officer documents as suspicious in its specificity. You knew exactly how much was there. You had documentation prepared. You were too ready with the explanation. Over-preparedness becomes an articulable fact. Either way, your answer is a contribution to the record rather than a defense against it. An answer that satisfies the officer does not typically end the inquiry. It provides a factual baseline against which everything else is measured, and every deviation from that baseline becomes additional documentation. The question, "Where'd you get this cash?" has no good answer that you can give at a traffic stop window. What it has is a constitutional response that removes you from the record entirely. Here is something most drivers never know, and it is the distinction that determines whether the cash leaves the scene in the officer's patrol car or in your vehicle. Civil asset forfeiture operates on a standard that is significantly lower than criminal prosecution. In federal forfeiture and in most state forfeiture proceedings, the government must establish by a preponderance of the evidence, more likely than not, that the property was connected to criminal activity. Not beyond a reasonable doubt, not clear and convincing evidence, more likely than not. And in many jurisdictions, the burden then shifts to the property owner to rebut that showing. The officer who documents that you were nervous, that your explanation was inconsistent, that the cash was bundled in a manner associated with drug transactions, that the drug dog alerted on the currency, and that you could not provide documentation of the cash's legitimate origin, has built a preponderance record from a traffic stop window conversation. You built it with him. Every answer, every hesitation, every piece of documentation you offered has become part of the government's more likely than not showing. Civil forfeiture does not require a conviction. It does not require a charge. It requires a documented record that the property was more likely than not connected to criminal activity. And a traffic stop window conversation, if the driver answers freely, often provides exactly that record. Knowing the standard is what makes the constitutional response not just advisable, but necessary. Here is what most drivers do when cash is found, and that question arrives. And every instinct that feels protective in the moment feeds directly into the forfeiture record that follows. The first driver immediately explains. They say it is money they saved, money from selling a car, money they withdrew for a trip, money a family member gave them. They reach for their phone to show a bank withdrawal. They volunteer the amount before they are told what was counted. Each piece of that explanation is now documented, and each piece will be cross-referenced against every other piece of information the officer collects. The second driver gets angry. They say this is their money. They earned it. The officer has no right to ask. The anger is documented as agitation. The statement, "I earned it," is documented as an unverified claim. The refusal to elaborate is documented as evasiveness in the absence of an invocation. Neither driver invoked anything. Neither driver placed their constitutional rights on the record. Both drivers provided material, one through cooperation and one through emotional reaction, that the officer will use in the documentation that justifies the seizure. The instinct to defend your money by explaining it is powerful and completely understandable. It is also the instinct that produces the most useful forfeiture documentation at the lowest cost to the investigation. The cash was found. Your explanation told the officer what narrative the forfeiture record needs to overcome. Here is the full constitutional architecture that applies the moment cash is found and that question is asked, and it contains protections that most drivers at a traffic stop window are never told exist. The Fourth Amendment governs the seizure itself. Cash cannot be seized without probable cause. Probable cause must be based on articulable facts, not the presence of cash alone, not a drug dog alert alone in most jurisdictions, not your nervousness alone. Specific, documented, articulable facts. The Fifth Amendment governs your response to the question. You are not required to provide the narrative that builds those articulable facts. You have the right to remain silent. That right extends to questions about property as much as it extends to questions about conduct. Invoking it cleanly and on camera means the officer must build his probable cause record without your contribution. The Fifth Amendment does not disappear because the subject of the question is money rather than criminal activity. It applies with equal force. United States v. Currency cases, civil forfeiture actions, have been challenged on Fifth Amendment grounds in federal courts, and the consistent principle is that the property owner cannot be compelled to testify against their own interest in the forfeiture proceeding. That protection begins at the traffic stop window. Rodriguez versus United States limits the stop's duration and scope. A cash discovery during a traffic stop does not automatically extend the stop's lawful duration. The officer must complete the stop's original mission and must have independent articulable suspicion to extend it for a cash investigation. Asking, on what independent basis are you extending this stop, places the Rodriguez requirement on the record before the extension becomes a prolonged interrogation. So here are the exact words. The moment the officer discovers cash and asks, "Where do you get this cash? Whose money is this? How much is this? Do you know how much cash you have?" or any variation of a cash origin inquiry, you respond this way, immediately and calmly. "Officer, I am invoking my Fifth Amendment right to remain silent. I do not consent to any searches or any seizure of my property. Am I free to go or am I being detained?" Say it once. Keep your voice level. Do not reach for your phone. Do not offer documentation. Do not add anything to it. Every word is doing specific constitutional work. "Officer, I am invoking my Fifth Amendment right to remain silent." You are removing yourself from the narrative construction that the question was designed to begin. The officer cannot document your answer as inconsistent, overprepared, suspicious, or evasive because there is no answer. There is an invocation. An invocation is not evidence. An invocation is a constitutional right being exercised. A jury that hears the driver invoke the Fifth Amendment has heard nothing incriminating. A jury that hears the driver said the money was from selling a car but could not produce documentation and became visibly agitated when asked follow-up questions has heard the beginning of a forfeiture narrative. I do not consent to any searches or any seizure of my property. You are placing your non-consent on the record before the seizure decision is made. If the officer seizes the cash after a clear statement of non-consent, he has done so over your objection, which means the seizure must stand on its own probable cause foundation without the cooperation that non-consent removed. The documentation of your objection is the foundation of the legal challenge to the seizure that follows. Am I free to go or am I being detained? The same legal hinge it always is. Forces the declaration, moves the burden, creates the record of when the detention began and what the officer articulated as its basis. The officer will push back and add a cash discovery. The pushback often carries a combination of authority and apparent reasonableness that makes the invocation feel inadequate. Know every line before it arrives. If the officer says, "I just need to know where the money came from," this will just take a second. The framing as a quick clarification does not change the legal character of the question. Your response does not change. If the officer says, "If you have nothing to hide, just tell me where you got it," your response does not change. Nothing to hide is not a constitutional standard. The Fifth Amendment does not have a nothing to hide exception. If the officer says, "I'm going to have to seize this until you can prove where it came from," officer, on what specific articulable facts are you basing probable cause for this seizure? I do not consent to the seizure of my property, and I am invoking my right to contest this seizure. Put the probable cause requirement on the record. Make him articulate it before the cash leaves your vehicle. If the officer produces a drug dog, officer, on what independent basis are you extending this stop to conduct a canine sniff? I am asserting my right under Rodriguez versus United States to be free from unreasonable detention. If the drug dog alerts, document the alert mentally. Note the time. Note whether the officer prompted the alert. Note whether any other drug indicators were present. The alert does not end your rights. It adds a fact to the officer's record, and that fact can be challenged at a forfeiture hearing with evidence about the dog's certification, alert rate, and the handler's conduct. If the officer begins counting the cash, officer, I do not consent to the seizure of my property. If a seizure receipt is produced, take it. Read it. Do not sign anything. Do not initial anything. I do not consent to this seizure goes on the record verbally, and your refusal to sign the receipt is your right. If handcuffs come out, I want an attorney. For words, everything stops. Here is the layer of civil asset forfeiture that most drivers never consider, and it is one that changes the calculation the moment you understand it. The agency that seizes cash during a traffic stop often keeps a percentage of the forfeited funds. Federal equitable sharing programs allow state and local law enforcement agencies to transfer forfeiture proceedings to the federal government and receive up to 80% of the forfeited assets back. In many jurisdictions, forfeiture revenue goes directly to the law enforcement budget, funding equipment, training, and operations. This financial structure means that a cash seizure is not a neutral investigative act. It is an act with a financial incentive attached to it. This is not a conspiracy. It is a documented feature of forfeiture law that courts, legislators, and legal scholars have debated for decades. It is relevant to you at a traffic stop window because it means that the officer asking, "Where do you get this cash?" is working within a system that profits from a particular answer, or, more precisely, from the absence of the correct one. The correct answer is not an explanation. The correct answer is a constitutional invocation that removes your contribution from a record that the system is financially incentivized to build. Knowing the incentive structure does not make the officer your adversary. It makes your constitutional response a necessity rather than an option. Here is one more layer that determines what happens to your money after it is taken. And it is the layer that makes what you say at the traffic stop window the most important legal event in the entire forfeiture process. Civil forfeiture challenges are expensive, slow, and procedurally complex. In many jurisdictions, you must file a claim within a short window, sometimes as few as 30 days, or the forfeiture becomes final by default. You must then prove by a preponderance of the evidence that the money was not connected to criminal activity. And the record the officer built at the traffic stop window, your statements, your behavior, your inconsistencies, your failure to invoke, is the evidence the government uses at that hearing. A driver who invoked at the window, who stated non-consent on camera, who asked for the probable cause basis of the seizure, and who said nothing beyond that invocation, has handed their attorney a clean record. The government's evidence at the forfeiture hearing consists of what the officer independently observed. The drug dog alert, if there was one. The cash's presence. The manner of bundling, if documented. What it does not include is anything you said, because you said nothing. That is the forfeiture hearing your attorney can win. A driver who explained, who offered documentation, who answered the follow-up questions, has handed the government a narrative to argue from and their attorney a record to overcome. The window conversation is the forfeiture hearing's first witness. Make sure that witness said nothing but the constitutional invocation. The body cam records everything from the moment the cash is discovered, and what it captures in the 60 seconds after that discovery is the most legally significant footage in the entire encounter, because it is the footage that determines whether your money was taken with your cooperation or over your clear constitutional objection. Judges reviewing forfeiture challenges watch specifically for whether the driver consented to the search that found the cash, whether the driver provided statements about the cash's origin, whether the driver invoked any constitutional rights, and whether the officer articulated independent probable cause for the seizure or relied on the driver's cooperation to build it. A driver whose body cam shows a calm invocation, a clear non-consent, a stated objection to the seizure, and a Rodriguez challenge to the stop's extension, gave their attorney a forfeiture challenge built on what the officer could independently justify, not on what the driver helped build. A driver whose body cam shows an explanation of where the money came from, an offer of documentation, visible nervousness under follow-up questioning, and no invocation of any kind, gave the government the narrative framework for a forfeiture it may never have been able to justify on its own. The body cam is the record of which of those two drivers showed up at the window. Make sure it shows the one who knew that "where do you get this cash" was not a question that required an answer. It was a question that required a constitution. Memorize these before you close this video. When cash is discovered and the origin question arrives in any form. Officer, I am invoking my Fifth Amendment right to remain silent. I do not consent to any searches or any seizure of my property. Am I free to go or am I being detained? If the officer continues questioning about the cash, Officer, I once again invoke my Fifth Amendment right to remain silent, and I will not answer questions without my attorney present. If the officer states he is seizing the cash, Officer, on what specific articulable facts are you basing probable cause for this seizure? I do not consent to this seizure. If a drug dog is deployed, Officer, on what independent basis are you extending this stop? I am asserting my right under Rodriguez versus United States to be free from unreasonable detention. If a seizure receipt is produced, take it, do not sign it, state verbally, I do not consent to this seizure. If a search of the vehicle is requested, officer, I do not consent to any searches of my vehicle. If handcuffs come out, I want an attorney. 6 positions, all grounded in the Fourth Amendment, the Fifth Amendment, Rodriguez versus United States, the civil forfeiture probable cause standard, and the financial structure of equitable sharing that makes your constitutional invocation not just a right, but a requirement. None of them confirm the cash's origin. None of them build the government's narrative. All of them place the constitutional burden exactly where the law requires it, on the officer who must independently justify the seizure, not on the driver who was never required to make that justification possible. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before an officer ever found your cash and asked where it came from, it did exactly what it was built to do. Subscribe to this channel right now, because civil asset forfeiture is one piece of a much larger picture of what your property rights look like during a traffic stop, and this channel covers every piece of it. What happens at the forfeiture hearing, how to file a claim before the default deadline, what your attorney needs from the body cam footage, and what the equitable sharing program means for your challenge's jurisdiction. Every scenario, every constitutional foundation, every exact set of words, so that when the cash is found and that question arrives, you are not explaining yourself into a forfeiture proceeding that the question was designed to start. You are the driver who already knew that the Constitution had an answer, and that the answer was not where you got it. Subscribe. Share this with every driver you know. Someone watching tonight is going to have cash found in their car tomorrow and instinctively explain every dollar of it because the question felt reasonable and the silence felt suspicious. Make sure they know the silence is not suspicious. It is constitutional. Make sure they know exactly what to say instead. Stay calm. Stay protected. Stay free.